He's gonna testify or whatever.
Hi, Mr. Parker.
How you doing?
Good, how are you?
All right.
I just wanted to give you this. I wanted to show you the copy too, because it doesn't scan as well.
All right.
So this is the original that has the certified record seal that I received from Pennsylvania.
Okay.
And so I just made you a copy so you can have it. I just want you to see that this one doesn't have the actual seal, that it is.
Okay,
in
yeah,
fact, a
that's
certified
fine.
copy.
Okay.
Huh?
I got what you're
Oh,
saying,
yeah.
you know, about the seal, all
Yes.
about the seal.
It's all about the seal and
Right.
that, yes, exactly.
Okay, then.
All right. Ready for this first announcement? Now, release the word present.
You may be seated. Why did you pause? What happened? I said, why did you pause? What happened? Ongoing conversation. 220062FY. This is State of Michigan versus Joshua West Allen Robinson. May I have your appearances, please?
Good afternoon, Your Honor. Sonam Movsisian on behalf of the people, P83923.
Good afternoon, NDS Detroit by James Parker on behalf of my client, Mr. Alan Robinson, P53832.
You state your name for me, please, sir.
Joshua West, Allen Robinson.
Thank you. Today is the day and time set for the preliminary examination in this matter. We have count 1, assault with intent to do great bodily harm less than murder. Count 2, weapons, felony, firearm. Count 3, weapons, firearms, possession by felon. Count 4, weapons, felony, firearm. Count 5, assault with a dangerous weapon, felonious assault. Count 6, weapons, felony, firearm. And count 7, domestic violence. Are the people ready to proceed?
Yes, Your Honor. Today, the people will only be proceeding with counts 3 and 4. Our complainant, Antoine Neal James, is not present despite being served a subpoena with notice of the date and time of today's preliminary exam. However, the people are able to proceed on counts 3 and 4 based on testimony by the responding police officer.
Is the defense ready to proceed?
We're ready to proceed, Your Honor.
Any other preliminary matters?
I do have a question, if that's okay, if I may raise with the court.
Yes, ma'am.
Do you, if the 2 counts will be bound over, do you know, does the domestic violence charge get bound over because it's a misdemeanor or because it's a third offense notice that does not get bound over with the felony counts?
It's my understanding that it doesn't, we don't have to do anything with it here. It would travel automatically with counts 3 and 4 should the people bear out their burden. Am I understanding it correctly, Mr. Parker?
Ordinarily, but my argument would be that if the complaint witness is not here at all, period, I feel that misdemeanor DV should not travel just because it's a misdemeanor on its face. And I'll make that objection for the court to decide whether or not they want to include that. You understand my argument?
I do understand your argument. I'm sure you'll go more into it at the close of the proofs.
I can,
Or now doesn't,
or at least preserve it at this point in time.
understood.
Okay, we can wait until closing. I just didn't know if it happens automatically or if I had to make some sort of argument for it, and so that will help me also decide. If this is new to me, so I've never seen it. I know generally the misdemeanors always carry. I didn't know if it just carries because it's a misdemeanor or because we have to prove something for the misdemeanor to carry.
I know you don't have to take testimony on a particular
Okay.
misdemeanor.
Correct.
Now, the point is, we don't have a witness period, and I still will,
Make that argument. Understood.
Thank you, I appreciate the guidance.
Anything else, ma'am?
No, that is all.
Any other preliminary matters, Mr. Parker?
I have none at this time, Your Honor.
Thank you. Your first witness, ma'am.
Yes, Your Honor, the people call Officer Phelps.
Good afternoon. Could you state your first and last name and then spell it for the court clerk?
Jacob Phelps, Jacob Phelps.
Raise your right hand for me, please. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
That's right.
Thank you. You can come up here and have a seat in this purple chair. The court reporter is taking down your statements. If for some reason she can't hear you, I'll either ask you to raise your voice or pull the microphone closer to your mouth, okay? Your witness.
Thank you, Your Honor. Good afternoon, Officer Phelps.
Good afternoon.
Where are you currently employed?
Romulus Police Department,
And what is your position with the Romulus Police Department?
patrol officer.
How long have you been employed with the Romulus Police Department?
About 1.5 years.
I'm sorry. Everything okay?
Yes, can you hear us?
I can hear you, but it's okay. We
Okay,
need to
I-
stop
I
if there's,
just asked my client just a little question that I didn't think the court could even hear what we were saying. I'm sorry about that.
you're fine. The two-story,
Does it just travel all
it
the time?
travels, and I don't want you to miss something because there's some issue you need to discuss with your client.
I understand.
Okay.
Thank you very much. I'll keep that in mind.
Okay, 1.5 years as patrol officer.
Thank you. Were you employed in that capacity on January 24th, 2022?
I was.
And what were your duties that day?
I was working my shift as a regular patrol,
And what shift was that?
midnight shift. We 11 PM to 7 in the morning.
Pursuant to your duties as a police officer, did you have an opportunity to go at or near 15054 Culver Avenue in Romulus?
Yes, ma'am.
And what kind of address is that, to your knowledge?
That would be a townhome.
And is that in Wayne County?
It is.
What led you to that location?
I was called there in response to a FATV, foreign assault, domestic violence.
Okay, do you mind just speaking up a little louder?
I was called there for a response to a FADV,
And so can you explain what FADV is?
felonious assault, domestic violence.
And what does felonious assault mean to you when you receive a call like that?
It means there's an assault that occurred with a dangerous weapon.
Okay. Did anyone else respond to the call with you?
Yes, ma'am.
Who was that?
Officer Salazar. And then Officer Shank later on.
And when you arrived at that location, did you make contact with anyone?
Yes, ma'am.
And who did you make contact with?
We first made contact with Mr. Robinson.
Okay. Do you see Mr. Robinson in the courtroom today?
I believe that's Mr. Robinson behind you. Yeah.
Can you identify what he is wearing?
He's wearing a blue and white striped shirt. He's got a blue medical mask on.
Thank you. Your Honor, for the people moved to identify the defendant as Mr. Alan Robinson.
Yes, ma'am.
Thank you. Once you made contact with Mr. Alan Robinson, what happened afterwards?
We initially made contact with him at the front door. He came out to meet us. Once we approached him, we knew that from the call that there was a gun involved. We immediately asked him where the gun was at, securing the scene so that we could get inside.
And when you asked him where the gun was at, did Mr. Robinson respond?
Yes, ma'am.
And what did he say?
He told us that that he had put the gun up prior to our arrival. He knew we were coming.
Okay, when you say put the gun up, what did you interpret that to mean?
I interpreted it to mean that he had put the gun somewhere safe, so that it wouldn't be any sort of danger to us.
Okay. And what kind of, based on your observations, what kind of townhome was this? Single story or double or two-story?
It's a two-story.
And so when you made entrance, where were you initially?
When you enter into the townhome, you enter into a living room area. Off to the right would be a kitchen.
Okay. And did you make contact with anyone else at that location?
Yes, we made contact with Miss James.
And who was she?
She would be the girlfriend to Mr. Robinson. She would be our caller.
Okay. And did you have an opportunity to speak with Miss James about what occurred that evening?
Yes. When I arrived, Miss James was in the bathroom still. She was on the phone with our dispatch. Once we arrived, we had detained Mr. Robinson. I announced myself, told her that it was safe to come out, that the police were here, and then I spoke to her upstairs.
Okay. And during the course of your investigation, were you able to determine whether an assault had in fact taken place?
Yes, I was.
Were you able to determine whether or not Miss James was the victim of that assault?
Yes, I was.
And during the course of your investigation, did you determine whether a weapon was used during that assault?
Yes, ma'am.
Do you know, or were you able to determine who had possession of that weapon?
Yes.
And who
Well,
was
I'm
that?
gonna start to object to this because now we're talking about certainly hearsay. And when the people are asking this particular witness a question, they're asking them to inject what a witness is saying to them. And obviously, we don't have that witness here. There is an issue of the fact that they're getting this information, testimonial information, for purposes of possibly a potential crime. And for those reasons, I object to this questioning specifically of getting in what the witness well, what was the reason for your call? What was the reason for your answer? That's one thing, but now she's getting into more specific details of what this officer is being told, and we don't have any type of verification for that.
Your Honor, I would disagree. I don't think that this falls under the hearsay category. I'm not asking anything specifically as to what Ms. James said. The officer is not stating anything specifically that Ms. James said. It's merely the steps that he took throughout the course of his investigation, that he had his own observations and statements that were made, and now he is relaying responses that do not state in any manner of any sort of other statements made by a third party.
Well, then my objection would be relevant. Why are we asking this particular question of this particular officer then?
Mr. Parker, I believe the question you objected to was Ms. Mosizian asking Officer Phelps, did he become aware of who had the gun or something along those lines?
Yeah.
Which I don't think, I'm gonna overrule your objection. I don't think it gets to hearsay yet. I haven't heard that he's repeating that so-and-so told him or,
Well, it's obvious that this officer didn't see the person with the gun because the people would be asking her directly, who had the gun? Who did you see have the gun? So what she's trying to do is, through this officer, get into the record that he's gonna say that he was told that my client had the gun.
I'm going to,
And that's hearsay. She's getting it from another person, and he's asking these questions obviously for testimonial purposes in terms of determining whether it's a potential crime, and that's just not allowed.
I understand your objection, Mr. Parker. I don't think we're quite there yet. We're getting dangerously close, though.
Okay, and my objection certainly goes back, not to this last point that you made about, did he have the gun, even before the question she asked before that. So when the people, or when the court said that we're getting dangerously close, I think she was dangerously close a couple of questions before.
But when you don't object, the court can't do anything except listen to the testimony like everyone else. Mhm.
I'm going back to your response that we're getting dangerously close. I felt she was getting dangerously close a couple of questions before.
I understand, and I believe the prosecutor is either going to pivot or change her line of questioning, but we'll see what happens.
Yes, I don't plan on getting into any told testimony. Am I able to repeat my last question? I don't think the witness answered it.
He did not answer it. You may repeat it.
Okay. Do you know who had possession of the weapon
Yes, ma'am.
and who was that?
That would be Mr. Robinson.
But see, when you ask that question, do you know? I mean, office, you weren't there. So again, I just think that's the improper question to ask him that question. Do you know?
I understand you're renewing your objection, Mr. Parker, but it could be as simple as, I saw a video of Mr. Robinson with a gun later on versus this person who's not here to testify today told me. So would you object if Officer Phelps said, well, I saw a video with a picture later of Mr. Robinson holding the gun at the time in question?
No, because he actually saw a picture of him holding the gun versus being told by somebody that this is what happened, and that person is not here to be questioned.
Did I miss the part where Officer Phelps said that somebody else put the gun in Mr. Robinson's hand?
No, I'm saying that it's, you asked me a question, would it be different if he saw a video of my client with the gun in his hand?
Right.
And I said, no, because the officer actually saw the video versus being told by somebody else, a third party, that they saw my client with a gun in his hand.
And in that vein is why I'm asking, maybe I missed something? I didn't hear Officer Phelps at any point say that somebody else told him that Mr. Robinson had the gun. Did I miss that testimony?
No, you didn't.
Okay.
Okay, but the question was just thrown out there, then, to me, that's pure speculation then.
Then your objection is speculation.
Speculation that, the officer couldn't have seen, he wasn't there to see that. So he can't answer that it was my client that had the gun.
And are you raising that objection right now?
Yes, I am.
Your response, ma'am?
I'm sorry, to the.
Speculation.
Speculation to the question
Okay.
and
let me
answer.
just Remember which. Oh, that whether or not the witness knew who had possession of the gun. I mean, Your Honor, I think it goes to what any officer does during an investigation, whether or not they have firsthand knowledge, I think is things that could be brought up on cross-examination. Certainly those questions could be asked by a defense attorney, but that doesn't mean that he didn't have any sort of knowledge as to what happened based on the course of an investigation that an officer conducts. And so, no, I don't think it's speculation when he's conducting an investigation and learns or discovers or determines or uncovers whatever, however you want to phrase it, of whether or not someone had a weapon.
Well, my objection is, if I make it more specific, I feel the question should be, officer, did you get some information about who had the gun? And then period. And then after that, when they start asking, well, who was it and who did they say, then that becomes hearsay. Certainly an officer is free to ask these questions. Certainly an officer is able to gather information. But the point is, now if the officer testifies that I know who has the gun, because I think that's what the question was, do you get information to determine who has the gun? I thought the word determine was used. If I missed that, because you're asking this officer to make a conclusion. And again, that's a form of conclusion about who had the gun. And again, that's my objection.
Mr. Parker, I'm going to again overrule your objection because I do not believe the way the question was asked required Officer Phelps to rely on information provided someone else. I thought the prosecutor's question was, were you able to determine? Was that how you phrased the question? Were you
Yes,
able to
that is
determine?
correct.
Determine what? Go ahead. What's the question? I
Would you
forgot.
like me to rephrase or restate
That
my
the
question?
defendant, that Mr. Robinson had the gun? I think we're splitting hairs.
Okay, and so you use the word determine just to feel that the information was given to the officer and not that it's a true fact. My objection would be that the way I feel that it's being phrased and asked, that you're asking for a conclusionary statement that, yes, my client has a gun.
Your objection was first hearsay,
Yes,
and Officer Phelps had not indicated, as far as I can recall, that he was relying on information provided someone else and providing his testimony about the gun. And then your objection was speculation. And we didn't get to where I didn't get from you where the speculation came from. Because again, Officer Phelps hadn't indicated that his information and testimony came from anything other than his own firsthand knowledge. I guess, maybe I missed it.
well, see, when you say firsthand knowledge, I'm saying that he didn't get firsthand knowledge from another witness.
How do you know that, though?
Well, I thought the question the line of the question the people were asking was, did you talk to somebody? And did you get information from somebody? And then from that, did you determine who this person was that had the gun? I thought that's the way.
Oh, I wasn't connecting the questions that way. Okay, I'm with you, sir.
I thought that's the way it started, that you had asked, you said that you were talking to somebody else.
Mhm.
and
Yes,
that
I'm sorry.
You were getting questions, you were getting information from this other person. So to me, that's not firsthand knowledge, that's still hearsay where he comes into court and the people ask him, have you determined who the person is that has the gun?
Okay,
I'm gonna be moving on anyways. That was really the last question that I had in regards to that. I don't think it falls under the hearsay category based on the way my questions were formulated. I think specifically goes to what Officer Phelps did in the course of his investigation, not him relaying other statements by third parties. But I can move on.
thank you.
While you were on scene, did Mr. Allen Robinson make any statements to you about the weapon?
He did.
And what kind of statements were those?
Initially, he told us that he had put the gun up prior to us arriving, because he knew we were arriving. And then he stated that he put it in the bedroom.
And where was the bedroom located?
He did not specify which bedroom.
Okay. Was there more than one bedroom?
There was,
Okay. Were all the bedrooms upstairs?
yes.
Okay. And at some point, did you or another officer recover a weapon?
Yes, ma'am.
And do you recall where that weapon was?
It was located under the mattress in the bedroom of Mr. Robinson and Ms. James.
And do you recall what kind of weapon it was that you recovered?
It was a 9mm Taurus. It would be a handgun, semi-automatic.
And what did you do after recovering the weapon?
We just collected it as evidence. The weapon was made safe and then taken back to Romulus Police Department.
Was anyone arrested during this incident?
Mr. Robinson was arrested.
And what did you arrest him for?
We arrested him for domestic violence.
When you located the weapon in the bedroom, did someone give you consent to look for it?
Ms. James gave us consent. She gave us her consent verbally, and then we requested that she fill out a consent to search form, which she did.
And based on your knowledge, based on your observations, was where you located the weapon sorry, I'm trying to think of how I want to phrase this. Where you located the weapon, was that in a, did that correspond with statements made by Mr. Robinson?
It did.
Did you in fact see Mr. Robinson holding the weapon?
I did not.
Your Honor, I have no further questions for this witness. However, I would like to put into evidence People's Exhibit 1, which is the defendant's prior criminal record, specifically in regards to the felony charge that he has. I did share this information with Mr. Parker, and so if I may approach, I do need it later.
Marked, okay.
It is a certified copy from
No
Pennsylvania.
objection, you don't use the power. No
Thank you, Your
objection.
Honor. Oh, thank you, Your Honor. Thank you, Mr. Parker.
I would like to say it is, this does fall under, in regards to the statute, the specified felony, because it was a prior felony drug conviction.
Thank you, ma'am. Yep, thank you.
I have no further questions. Thank you.
Thank you, Mr. Parker.
Officer, I missed your last name, sorry about that.
Phelps.
Robinson?
Phelps, P-A-T-L-P-S.
Phelps, Your Honor.
Yes.
Phelps. Now, you were there, who was your partner?
I was there with Officer Salazar and Officer Shank.
Okay, then, who was with you when you approached that location, the door specifically?
That'd be Officer Salazar.
Salazar. And when you went up there, the person that met you was Mr. Allen Robinson.
Yes, sir.
Now, you stated that you had a discussion with Mr. Allen Robinson.
Yes, sir.
Allen Robinson.
Yes, sir.
Did- Okay, and in this discussion, you questioned him about what was going on?
Briefly, yes.
Briefly?
He came to the door as we were approaching.
All right.
He knew we were on our way. He had been on the phone with our dispatch as well, I believe. And he knew we were gonna be there. He opened the door for us.
So he was on the phone with your dispatcher, you knew that?
I think he had at least called them. I don't know if he currently was when we came to the door, but I want to say he at least called them.
All right. So then you and Officer Salazar approached Mr. Allen Robinson, and you have a discussion with him.
Yes, sir.
After you have this discussion, how long does it last?
It was just for a few moments.
Few
We were,
moments.
yes, sir.
And at this point in time is when you got information, or did you question him about a weapon?
Yes, we did.
All right. This discussion that you talked about that lasted for a few moments,
Mhm.
did you ever have another discussion with Mr. Allen Robinson that particular evening?
Yes, we spoke to him a few different times throughout the entirety of the incident.
Throughout the entire incident? After you had that initial discussion, is that when you recovered a weapon?
It took us some time to find a weapon.
It took you some time to find the weapon. So how long is some time? You have an idea?
I would have to speculate. Could have been 20 minutes that we were there.
20 minutes? Okay. And this is a two-family flat, right?
I don't know what you mean by that.
Two-family, or upstairs to the
two-story?
downstairs.
Yes,
Maybe not a two-family flat, sorry. Upstairs to the downstairs.
yes, sir.
And you approached Mr. Allen Robinson at the front door,
Yes, sir.
and is that where he remained while you did your search?
No, we detained him. We placed him in handcuffs. We took him into the kitchen area after our initial contact at the door.
All right. And he remained in that kitchen area until you recovered the gun, that fair to say?
Yes.
Okay. Prosecutor just asked you a question, what did Mr. Allen Robinson say to you specifically?
Yes.
What were those words?
He stated that he had put the gun up. The question was, where was the gun? And this was as we were approaching the location. He stated he had put the gun up and he had put it in the bedroom.
Okay. And that is all that he said, is that correct?
At that initial time, yes.
And then at that time, you talked to Ms. James, is that fair to say?
Yes, we made entry into the location at that time. We had to get her out of the bathroom.
Okay. But you talked to Ms. James, is that correct?
That's correct.
All right, then. Were you the one that recovered the weapon?
I was not.
Okay, did you put the weapon on lock of evidence tag, all that type of stuff?
Yes,
You determine who the weapon belonged to?
yes.
Okay, who is it?
It's registered to Miss James.
Ms. James? Okay. And when you obviously got there, and the people have asked you this question, I'll ask it again. My client was not in possession of a weapon with him.
No, he was not.
And it took you some 20 minutes to find that weapon, is that fair to say?
We weren't searching for the 20 minutes. It just, by the time we started the search, it might have been 20 minutes into our investigation,
Got you.
just because of we want to do things right, so,
Sure. But you eventually found it in a bedroom.
yes.
In one of the bedrooms. How many bedrooms are there?
I believe there are 3.
3, okay. I have no further questions at this time.
Thank you, sir. Any redirect?
Just one quick question. Did you learn whether or not do you know who was residing at this residence?
I believe it's just the 2 of them.
Okay. Do you know how long Mr. Allen Robinson was living there?
Well, I'm going to ask for the relevancy of this particular line of question.
Can't respond.
Yes.
Oh, okay, sorry, I didn't know if you wanted to.
No,
say
I'm looking
something
at you
first.
for you to respond, sorry.
Your Honor, it's mostly, it'll go, I think when I make my argument at the end of just that, the fact that the defendant was in the residence where a weapon was present. And so I just wanted to note that it wasn't something like he stopped by for a couple hours, that he was in fact living at this residence.
Again, I don't see the relevancy.
I'll sustain his objection. I don't know the duration of
Oh.
the time of Mr. Allen Robinson in the house.
Okay, that's fine, that's fair.
Were you saying something, Mr. Parker?
No.
Okay,
Okay, that's all, thank you.
thank you. Thank you, Officer Phelps. You may step down. Have a good afternoon, okay? Your next witness, ma'am.
Your Honor, the people have no other witnesses to call, thank you.
Mr. Parker,
I have none at this time, Your Honor.
argument.
Your Honor, the people request to bind over counts 3, possession by a felon, and count 4, felony firearm. In order to establish by probable cause for the preliminary exam, the people must show that the defendant has a prior conviction, which we presented a certified copy of his prior specified felony conviction for a drug offense, and that he should not have been anywhere near any sort of firearm, let alone possess a firearm. In order to show possession, there can be actual possession, or if the person knows of the location and has reasonable access to it. The people believe that we have proved both of those. Based on the statements given by the witness, Officer Phelps, he had responded to a felonious assault, domestic violence 911 call. They had reason to suspect that a weapon was used in an assault. When they initially approached the house, that was the first question that they asked Mr. Allen Robinson as to where the gun was. Mr. Robinson made statements in regards to where the weapon was. He stated that he put it up, and then that he put it in the bedroom. And so just based on that, he had some sort of possession of the firearm. Additionally, officers were able to determine, based on their investigation, that that firearm was in fact used to commit an assault, and that assault was committed by Mr. Allen Robinson. And therefore, for purposes of preliminary exam, the people believe that we have met our burden to establish probable cause that in fact, Mr. Allen Robinson should not have been anywhere near a weapon, but that he possessed a weapon, and that he is legally not allowed to do so. Thank you.
Well, Your Honor, I certainly object to the bind over. Again, the people have used that phrase determined, the officers have determined. Now, the officers have gone to the scene, and that's all that they have done this particular evening, and they gathered evidence, which officers are supposed to do. But nevertheless, they again make it a conclusionary statement that they determined, again, I object to that. But nevertheless, my client and this charge, you have to show possession. There was no actual possession. There was no constructive possession. My client, as the people had questioned the officer, I did too, when they came to the particular house, my client was downstairs at the front door, and they asked about a weapon. Information was given that it's upstairs in a bedroom. And certainly that is not any place that you could establish any type of constructive possession, let alone actual possession. Certainly, when people argue that my client has no business to be around a weapon or have actual possession of a weapon, it's a difference. My client, as they have established either through delivered testimony, was there at that house, and if they're arguing about a DV, then obviously there's some type of relationship. But the officer clearly stated that that weapon that they recovered that particular evening belonged to Miss James. And my client, again, did not have any type of actual possession or constructive possession. And I feel because of that, this case should be dismissed.
Nothing else, Your Honor, thank you.
Court did have the opportunity to listen to the testimony of Officer Phelps this afternoon, and will bind the defendant over on counts 3 and 4 of the complaint, that being in possession of the weapon by the felon and felony firearm, both on direct examination and cross-examination. Officer Phelps was clear and consistent in stating that Mr. Allen Robinson stated, "I put the gun up." So at some point had possession of the weapon sufficient for probable cause at this preliminary exam stage. The next step in these proceedings is the arraignment on the information, which will be 2 weeks from today. It's February 28th, 2022 at 9:00 a.m. His previously entered bond with any conditions shall continue. Anything else on behalf of the people?
I'm sorry, can you restate that, the date again?
The 28th.
The 28th.
Yes, ma'am. Anything else, ma'am?
I have nothing at this time.
Thank you, Mr. Parker.
And just to be clear, Judge, so the misdemeanor will not continue with the rest of the file.
The misdemeanor automatically continues. Mr. Parker's issue, I believe, was about the third offense notice. And when I look at the bind over document, it doesn't list the third offense notice as its own freestanding charge that gets bound over. I believe that the proper place to make the argument is in circuit court. Do you want to go into that, Mr. Parker?
Now we're talking about the fact that my client has a couple of prior convictions. That part I really wasn't arguing. Part that I was arguing, and I'll research it and I'll go into it, I guess, circuit court, is whether or not that misdemeanor can follow if we had, if the complainant was not here at all. I knew we weren't going to take testimony, and we usually just say, we don't have to address it. But does it actually follow, knowing that all the other charges that the complainant witness would have needed to be here to find those charges over and not the misdemeanor? You understand what I'm saying?
I do understand what you're saying, and it's been my understanding that because the exam is only about the probable cause for the felonies, that we don't take testimony, so it doesn't matter if none of the witnesses who could make out the misdemeanor crime are present at the exam. If you find out something different, I'd be interested to
I
know.
will research that, but I never had this situation happen where we would find over that particular part.
Okay,
That's something I will look into, and I'll bring it up in circuit court.
and bring it up the next time you're here, because I am extremely curious how that resolves itself. If we're not taking testimony, what does it matter that a necessary witness for that misdemeanor is not present? But that's more an aside than anything else.
I will look into it as well. I'm just curious, because I'm sure I'm gonna have this actually come up a lot more,
'Cause-
given the nature of these cases, and so.
So you and Mr. Parker will work on it together? Is that what
Yes.
you're telling me? Okay.
Okay, thank you. So I'll note that on my file as well, that
How many killings you got?
that carries. Okay, thank you.
Thank you.
I appreciate it. Thank you.
Your Honor, can I address the bond?
The bond is posted to 10,000, 10%.
And it's really about the tellers.
Oh,
My client does have two tellers on.
how do you have on two tellers? How does that work?
That's what they gave me, because they,
And-
sorry, that's what they gave me when I left Wayne County, I guess, for like an older, order, but the order was canceled out, so I don't know why they got that old order.
Your Honor,
One's, I believe, an alcohol tether, the other one's a GPS tether. So my client obviously has to respond to both of them, and that is a hassle to do both of them. I understand if the people want one, but I'll make the argument now. We have a case that even though the DV did carry through, even though we didn't have any complaining witness, I have to vote with them at this point in time. Because I'm quite sure it's not going to make contact with the wrong. Complaining witness.
Ma'am,
Your Honor, I will leave it up to the court's discretion for the GPS portion of the tether, given that, the assaultive aspects of these crimes did not get bind over, so our main complainant, is not, is not moving forward with the charges. However, I will say, with the contact I have had with the complainant, which I have, it's not that she, didn't respond whatsoever. I have had several conversations with her in regards to this case. And even from the get-go, her initial complaint, or her initial, I guess, concern was the alcohol consumption and what that leads to. And so my biggest hesitation would be to remove the alcohol tether, and then if some, especially with a no contact order being also, or the GPS tether also being removed, that something could result again in a very similar manner as to why this initial incident took place, where the defendant was under the consumption of alcohol. Again, I don't mean to insinuate that there's any sort of drug or alcohol problem, but I do think the complainant made it very clear to me that an issue has been when the defendant consumes alcohol, some of this aggression results. And so my only request would be then, if the court is inclined to remove one of them, the alcohol tether would remain, especially just given the fact that if the no contact order is removed, as well as the GPS, to ensure that, no other problems kind of occur in regards to alcohol consumption and then a possible assault.
the court didn't hear anything about alcohol this afternoon, and when we were here on February 2nd, Mr. Allen Robinson's mother came on, right?
Yes, you did.
And we had this conversation about an alcohol tether, and because Judge Green put it on, this court was reluctant to take it off because of the number and the severity of the charges, but I haven't heard anything about alcohol being the issue, and if your concern is the safety of the complainant, and Mr. Parker is only asking that one or the other be removed, this court is more inclined to leave the no contact or the GPS tether in place and remove the alcohol tether. Is there some?
It's in the police report. I did not give testimony because I didn't realize that that would be necessary to remain the tether on. It was in the police report itself saying that the victim made statements in regards to the defendant's alcohol consumption prior to the police arriving at the location, as well as prior incidents with alcohol. And so even the defendant's mother, if I remember correctly, stated that it's not that he has issues with alcohol, it's so what happens when alcohol consumption occurs, as well as other possible like mental health issues that need to be addressed. But I think both of them were pretty open with the court with the alcohol tether remaining. It was more of a clarification that she thought alcohol tether meant someone had an alcohol substance abuse problem. And I don't think the two correlate. It's more of, was alcohol part of an issue that led to this incident? And I think the police report makes that clear that it was.
Your Honor.
But
Your Honor, wait.
I was gonna say, I will leave it up to your discretion on both. I just wanted to state that that's the main concern the complainant has had throughout this process. And I know she's not present, so I just wanted to relay that to the court, but I will allow you to determine what is best. Thank you.
Your Honor, we'll concede that we can leave the alcohol tether out, so we just have a GPS. It doesn't have GPS. That's fine.
You're not asking me if that's fine. You're asking Ms.
Yes, I am.
You're asking Ms. Mosivia, because she's the one that's had the contact with the complainant. All I know is that Mr. Allen Robinson's mother came on and stayed on. It was very polite 2 weeks ago. The testimony that Officer Phelps gave this afternoon, and that another judge set his bond and put these tethers in place. That's all I know. So if Ms. Mosizin is saying that they're more concerned about the alcohol than the location, then I'll remove the location. If the complainant is more concerned about where he is and whether he's drinking, we'll do the reverse. I have no skin in the game, and this case is going downtown, so
And that's why I said, we'll keep the alcohol tether.
Yeah, I mean, just based on my conversation with the complainant, that seems to be a bigger issue. And so,
modified bond to remove remove GPS tether. The no contact order remains in place. And Mr. Allen Robinson, you don't need to respond to me when I say this, but I'll say, if you make efforts to communicate with the complainant in this case, Ms. James, The judge assigned to the case downtown might see that as a violation of your bond and revoke your bond, and you can spend the rest of these proceedings incarcerated, well, in custody. So no contact means no contact, no direct contact, no contact with third persons, no contact with social media. Understood. Anything else?
No, that's all. Thank you, Your Honor.
Anything else?
Thank you.
Thank you, sir. We're all set.
Thank you.
They'll get the paperwork